1996, CI 16. In this regard, we think that the current High Court Civil Procedure Rules 2004, CI 47, particularly Rule 12.6 of Order 11 on application for further and better particulars and Order 22 on interrogatories are beneficial to us by way of guidance as to the appropriate practice to prescribe in the course of the exercise of the original jurisdiction of the Supreme Court. It is Rule Order 22, Rule 1, that is expressly referred to in that decision. It is to that order. It is to that order that we make reference when I stated that we are coming under Rule 5 and Order 22 of CI 47. And my Lord, that statement of His Lordship Justice Badegbe is further reinforced by the provision in Article 1284 of the Constitution of the Republic of Ghana. And Article 1284 provides that for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So the Constitution makes it explicit that your lordships have the power that is vested in every other court. I'm sorry, 1294. 1294. I read it right, but I didn't. 1294, yes. My lords, the clear purpose of discovery under CI 47, the clear purpose yes, of discovery. Interrogatories are part of the process.
Okay, in that sense, okay.
And I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court. And my lords, all the proposed interrogatories, and there are 12 of them, in our respectful submission, are designed precisely to narrow down the issues for trial. Your Lordships will, if I may respectfully refer to Order 22, Rule 1, from where your Lordships will see, which is headed Discovery by Interrogatories. And Rule 1.1, a party may apply for an order giving the party leave to serve on another party interrogatories relating to any matter in question between the applicant and that other party in the cause or matter, and B, requesting that other party to answer the interrogatories on affidavit within such period as may be specified in the order. Rule 1.2 then makes reference to Form 10 in the schedule, and Form 11 is the answer that will be provided. We have complied with the Form 10 in the schedule in indicating what we are asking for leave to serve by way of interrogatories. And your Lordships will observe that starting from number 1 in the interrogatories, where, before I get into the specifics, there is another passage in the Judgment of Justice Badegbe that I wanted to refer to, and I would respectfully ask your leave to do that before I go into the specifics. And this is a passage from page 59 to page 60 of the judgment. And his Lordship says as follows: this leaves us with the application of the petitioners for interrogatories directed at the second respondent electoral commission. The application has been resisted on the ground that it has the effect of allowing the requesting party, the petitioners, to fish for information. If the said contention is correct, then the application must fail. We have carefully considered the application, and we are of the view that the request does not come within the designation of the word fishing as pronounced by Greer Lord Justice in the case of Rofe and Kevorkian, wherein he observed, and then he quotes that. And his Lordship, after quoting from that English authority, says, we have carefully examined the application relating to the request of the petitioners and are satisfied that they are within the scope of permissible interrogatory. So in that particular instance, the lordships allowed the interrogatories to be served on the second petitioner. And that is what we are seeking for your lordships to do in this case. In the specific interrogatories, we have questions regarding, in number 1, the practice in previous presidential elections involving collated figures from constituencies being received in the strong room in the presence of agents, and the further question whether that practice was followed, and the third question whether the 7th December presidential election was the first time regional collation centers have been interposed between constituency collation centers and the headquarters of the first respondent. My Lord, respectfully, these are matters which in the answer of the first respondent in paragraph 5 of the answer particularly, the first respondent sets out a procedure that the first respondent says is the procedure as detailed below. So, my Lord, these questions about the regional collation centers are directly related to what the first respondent sets out in paragraph 5. And equally, the question in question 4, how the results were transmitted from the constituency collation center to the regional collation center, that is clearly a question that arises from the process that is described, and that is clearly relevant. Yes.
Question 4. Should I understand it to mean the mode of transmission of the result? Is that what you are referring to?
That is correct. That is correct. And related to that, we also have in 6 a very specific question. Did the National Communication Authority facilitate in any way the transmission of results to the headquarters of first respondent? Again, that's a very specific question as regards whether the National Communication Authority facilitated in any way the transmission of results to the headquarters of first respondent. My Lord, respectfully, I mean, the issue of the mode of transmission is very important, especially for determining the authenticity of what was transmitted. And so it is very much at the heart of what is before your lordships in this petition. And whether the National Communication Authority facilitated is again capable of a very simple answer: yes or no. And in question 7, the interrogatory seeks to find out, when did Mrs. Jean Adukwe Mensah, is it Adukwe or Adukwe? Adukwe, yes. When did Mrs. Jean Adukwe Mensah, the chairperson of first respondent and the returning officer for the presidential election, first realized there were errors in figures she had announced in her declaration of 9 December 2020? When? This is a question only one person in the world can answer.
Mr. Chikata, why wouldn't you limit?
I'm sorry?
Why wouldn't you limit your references to the EC to the office, the chairperson, rather than the personality? It seems to me that your attack is against the personality of the person and not the office. So we'll be happy if you just limit it to the chairperson
Lord,
of the
respectfully,
EC, because in their absence, any of the deputies, anybody at all could step in.
respectfully, my lords, there is only one returning officer for the presidential elections.
And that is the
that returning officer is not the EC. That returning officer is the chairperson of the Electoral Commission.
And that chairperson, that's all. We are not
The
interested.
chairperson has a name. I'm not able to mention the name of the chairperson. No, my lord, respectfully, I want to understand. Am I being prohibited from mentioning the name of the chairperson? Is that the issue?
Reading through your petition
Yes.
as to the instant application, the constant emphasis on the name. What I'm telling you is that we'll be satisfied just with the designation, because in her absence, any of the deputies could act in that position.
My lord,
So if it is an election petition, and you are challenging the election of the president, it is sufficient that the institution charged with the responsibility of conducting that election had done their work, and the chairperson, who is the head, represents that institution, and not the personality, the name.
my lords, with the greatest respect, I believe that the constitutional requirements regarding the returning officer and the particular circumstances that we are dealing with in this case do not make it possible to have the situation that you are envisaging, where somebody else steps in for the chairperson. Respectfully, the Constitution makes the chairperson and only that chairperson the returning officer. And in the circumstances of this case, that chairperson happened to be the person that we refer to in the petition. And that chairperson actually was the person who undertook her responsibilities in accordance with the various constitutional and legal provisions that we have. So, my lord, we do not mention her name by way of targeting an individual. That is very far from it. My lord, when I cited before you a decision of the Supreme Court, and I cited the decision of Justice Badegbe as an individual judge, he read a unanimous decision of the whole court. I did not target Mr. Justice Badegbe when I mentioned his name, because he happened to read that judgment, which was a unanimous decision of the court. And equally, I do not target Mrs. Jean Adukoya-Mensah when I say that she made the declaration on the 9th of December. It's not a targeting, it's just a fact that is material in this particular petition.
So thank you. You may continue with your submission.
And that is why in the next interrogatory 8, the question is again posed: how did Mrs. Jean Adukoya-Mensah, the chairperson of First Respondent and the returning officer for the presidential election, get to realize there were errors in figures she had announced in her declaration? And respectfully, my lords, as I said in respect of question 7, there is only one person who can testify to those matters. And question 9, in respect of the purported corrections, and we put corrections in quotations because, I mean, whether there were corrections or not is itself an issue. In respect of the purported correction made to the figures in the declaration by the first respondent, was there any prior process of conferring with agents of the presidential candidates? And then 10, did Mrs. Jean Adukwe Mensah, the chairperson of first respondent, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? 11 is on which date did Mrs. Jean Adukwe Mensah?
Mr. Jikata, Adukwe in Ghana is a male. The female is Adukwe. She's not Adukwe.
I can only bow to the superior local knowledge of your lordship. So Adukwe, most grateful. My friends could not help me, but I'm grateful. I'm grateful to your lordship. Adukwe. And we seek to ask whether that is 10. Did Mrs. Jean Adukwe Mensah, the chairperson of first respondent, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? And 11, on which date did Mrs. Jean Adukwe Mensah, the chairperson of first respondent, post a copy of the Form 13 at the head office of the first respondent? And 12, did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the results? So each of these questions, which is capable of a relatively simple answer, we believe will narrow down the issues that are before this court. Your lordships will be aware that Regulation 44 of the Public Election Regulations sets out, particularly 4410, it sets out what the chairman of the commission, the CI 127 assumes that it will be a chairman, but the chairman of the commission it sets out exactly what is done in connection with the process. And the interrogatories that we are filing will, by clarifying these matters, will narrow down the scope of the inquiry before your lordships. We have this morning been served with an affidavit in opposition by the first respondent. And I would simply say to your lordships in this context that nothing in that affidavit in opposition provides a justification for us not being granted leave. My lords, in paragraph 4, following paragraph 3, in which the first respondent, which the affidavit is sworn to by Mrs. Jean Adukwe Mensah. And in paragraph 4, she says, I object to answer to paragraphs 1 to 3 as irrelevant as the steps taken by the first respondent is in accordance with the Public Election Regulations CI 127. My lords, with the greatest respect, whether they are in accordance or not in accordance is an issue before this court. Whether what has been done by her is in accordance with the Public Election Regulation is precisely an issue before this court. And that issue is not going to be determined by a paragraph in her affidavit. Indeed, my lords, the logic of the questions 1 to 3 should be obvious on the face of those questions. Questions 1 to 3 start from the practice before to whether, in 3, whether the first time regional collation centers have been interposed between constituency collation centers and the headquarters of first respondent is in the 7th December 2020 election. So, my lord, there can be no basis for saying that these questions are irrelevant to determine what actually happened, which is what this case is about. And in paragraph 5, she proceeds to object to answer 4, 5, 6, 7, and 8. Now, my lord, 4 is how were results transmitted from the constituency collation center to the regional collation centers. My lord, I mean, this question can hardly be irrelevant to this petition, because this question about how results were transmitted is critical for the determination of the authenticity that she's claiming for the results that she declared.
Mr. Chikata, could you kindly point to the paragraph of your petition that this question is related to?
The paragraph that is related to is the paragraph of the first respondent's petition, as I indicated earlier. The answer.
Which paragraph?
The first respondent.
Which paragraph?
Paragraph 5, I referred to earlier. Paragraph 5, where she sets out, where the first respondent, not she this time, the first respondent, Electoral Commission, sets out the 4-stage procedure.
Thank you very much. Thank you very much.
And so my submission, the question how this collation was transmitted, or how the results from the collation center at the constituency were transmitted to the regional collation center, and how the results transmitted from regional collation were transmitted to the headquarters. Those questions 4 and 5 are clearly critical to what was actually done in this election, not just what is required to be done in general terms, but what was actually done. And Lords, we cannot see how questions 6, 7, and 8 can be described as irrelevant either. And my lords, in paragraph 6, with respect, what the deponent seeks to do there is to anticipate your lordship's granting us leave, because she's giving an answer to that question, and respectfully we would like her to wait until you have given us leave to serve her, and then we can read her answer at that point. She is anticipating it in paragraph 6, and we are grateful for that anticipation, but that should await your lordship's grant of leave, and the service on her, the service on the first respondent of the interrogatories. My lords, there are other responses in the remaining paragraphs. I only comment on the one suggestion that we are unnecessarily attempting to delay the trial. Nothing could be farther from the truth. And we actually take exception to that suggestion and that averment in the affidavit. We take strong exception, in fact, I may say, to that suggestion that we are attempting. The purpose of discovery, as I've indicated, is to limit the matters for trial. And if only she would just stick to answering those interrogatories, I think the processes of this trial would be expedited, rather than to make facetious statements about our intentions. We're therefore respectfully asking that your lordships grant us leave, and I believe that upon these interrogatories being filed, they can accelerate the processes for responses from the first respondent, and therefore for the further processes of this trial. That is all. Yes, my lords. My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit. Lords, the answer to the question are in the petitioner's own petition. The answer filed by
first respondent, also by the second respondent. Hello. Regulation 44(9) of CI 27 sets out how the first clear result, and in it, questions being asked of us. Did the regulation pop up from? It's all in the law. That is saying that it is in the law before this court, and those are the steps that the first respondent followed. Hello.
Section of the.
Hello. Right. Regulation 44 sub 9. Regional collation officer shall, upon receipt of the presidential election collation as set out in Form 9, the presidential election results summary sheet as set out in Form 10 of the schedule from the district electoral officer in the presence of the public and with not more than 2 counting agents appointed by the parties contesting or the polling agents of the party. The presidential results from the constituencies as set out in Form of the schedule. Fill the presidential regional results form as set out in Form 11 of the schedule. Presidential regional results summary sheet as set out in Form 12 of the schedule. Request the so my lords, it is all set. It's where what is done at the regional level. My lords, we said in our answer that indeed the had signed 13 of those. We have also stated in our answer that where a party fails or refuses to sign on any of the forms at this stage of the process goes on. Just a second.
That you are submitting before the court that your responsibility is stated in the law as you rightly stated there. So can you? I know depending on the ruling of this court, you may have to answer or. But
my lord, regarding you are asking about question 4 and 5. Yes, because as we have stated, I think somewhere in the answer it's translated by facts. My lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court. My lords, I wish to refer your lordships to the case of Nana Addo Dankwa Akufo-Addo versus John Dramani Mahama and the EC. Lords, is reported at page 61 of the special edition of the Supreme Court of Ghana Law Reports. My lords, I would draw the court's attention to page 71, and with your kind permission, let me read what the court, the Supreme Court, speaking to Adina JSC said. In the circumstances, we hold that the petitioners are sufficiently and well informed about the election results which which has enabled them to mount this petition on grounds of malpractices in 4,709 polling stations based on the contents of these duplicate documents in their possession. The affidavit in support of the application does not disclose any need for the inspection and making photocopies of original documents. Thus, I wish the court to apply this decision and hold that the matters for which the petitioner seeks interrogatories are well within his domain, and he was well armed with those before he filed the petition in this matter, and therefore he is bound by his pleadings in the petition, and therefore cannot come through the back door and seek further information through these means. Plus, I would also wish to refer your lordships to the Metonunu case. Because it is Metonunu and others versus the Electoral Commission, 2007 to 2008, Supreme Court of Ghana Law Report 1250. Lords, I wish to draw the court's attention, with your kind permission, to the obiter dictum of Dateban JSC. It says, it should be noted in particular that Article 49.3 requires the announcement of the voting at the polling stations before they are communicated to the polling officer. Such announcement has the effect of the results in the public domain. Observance of Article 47 means in effect that the Independent Commission publishes at each polling station the results from that station. We do not therefore see the need to as a condition of the validity of the declaration of the election of the president-elect, the added publication obligation that the plaintiffs have argued in this case. If the election system operated by the defendant could not function without such a publication, we could have been persuaded to imply such a publication in order to make the system workable. So, my lords, the point we are making is that there are 8,000 polling stations countrywide. Petitioner are appointed agents in each polling station. The results were forms filled, his agent refused to sign, he moved on to the constituency, he had agents there, they signed, if they refused to sign, he moved on to, and so on, and then the presidential returning officer got all these sheets. The petitioner's own agent signed 13 of them. The second respondent's agent signed 14 of them. Of the 12 other agents signed, there was no total signature on all the 16, but based on the system. So, my lords, the information seeking well before the court in the petition, in the answer. Therefore, it's our prayer that the petition be refused.
Mr. Amenuvo,
yes, my lord.
My understanding of part of the submissions of the petitioner is that in 2013, during the 2013 election petition, an application was made for interrogatories by the then petitioner before this court. And the court granted it.
Yes,
the decision given by Gadebe JSC at from page 54. And so this is a similar application for interrogatories, which is before us. So this is being used as precedent. No. So what do you say? Because counsel is entitled to rely on precedent and invite the court to follow precedent already set up.
My Lord, distinguishable precedent. Distinguishable precedent. My Lord, with respect, the 2013 situation is different. And mind you, my Lord, interrogatories, grant or refusal is discretionary. And it has to be based on the set of facts at every situation. It doesn't arise in this case. It doesn't. And that is why I said, yes, there is precedent, but precedent is distinguishable based on the facts and the processes that are before you in the pleadings, my lords.
So why are you saying that in this particular case, it is not applicable? In
My
this
Lord,
particular petition, why are you saying it is not?
Beloved, because the answer he seeks are all in the document before the court. And then the law that they themselves are rely on, we also rely on. They are there. I just read to you the steps. You are asking me that when did the original issue come up, etc. If you read the law, you see that it's in there.
Thank you.
Thank you very much, my lords.
My lords, I pray that I be permitted to make a few observations of law.
Are you making observations or you should be permitted to respond?
Submissions.
I think the application is basically directed at the first respondent. Because you will not be compelled to answer any question. If I understood counsel for the petitioner, you are not under any obligation whatsoever to answer any of the questions serialized in the document annexed to the affidavit.
Yes, my lord, it is true that no specific interrogatory has been directed to the second respondent. However, we are an interested party in this matter, and if we can assist the court on legal issues, we think we should be permitted to do so.
Yeah, Mr. Kuchampa, if, as you rightly said, if it's a legal issue, if it's a question of law, we can hear you, because seriously you did not file enough in position with regard to the facts.
That is what
So, as a party in the petition and an interested party, if there's any legal point you want to address for the benefit of the court and all the parties, I think you can do so.
My lord, very briefly. My lord, I think the first point to make is that interrogatories must relate to matters in contention between the parties. And that is clearly set out, my lords, in Order 22, Rule 1A, Rule 1, Sub 1A. It reads, with your permission, the party may apply for an order, A, giving the party leave to serve on another party interrogatories relating to any matter in question between the parties. My lord, and it is further reaffirmed by 6A of the same rule, which states a proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC. Furthermore, my lords, it is a case that if your lordships consider the questions as to NCA, there's nothing in the petitioner's case that raises that matter as an issue. Very well. So my lords, that
allowed to make some raise points of law to assist the court.
yes, my lord.
You are
Now,
taking that
finally,
yes,
the
outside
final point I
the
want
scope.
to
Yes.
make is that counsel for the petitioner referred to Badagry JSC statement in the earlier presidential petition, but he did not quote Grill LJ, because what Grill LJ said is significant. And my lords, with your permission, I'll read from here. It is, however, the nature of fishing interrogatory trying to get, for the purpose of the defendant's case, evidence which he has not already got. On these grounds, having regard to what has frequently been decided, that because any question is a proper question to put in cross-examination, it is not therefore necessarily a proper question to put in interrogatories. We have decided that interrogatory 3 also ought to be disallowed as being a fishing interrogatory. And my lords, it is our submission that these interrogatories are indeed fishing interrogatories and should be disallowed.
May I, with your leave, just address a couple of points? Lord, I would respectfully first observe that counsel for the first respondent, in effect, admits the relevance of these interrogatories, because he claims that they are dealt with in their answer. So there can't be any doubt that they are relevant. And the question whether they are in fact dealt with in the answer is a question that your lordships are going to have to decide. But he said that those matters in the interrogatory are dealt with in the answer. Now, my lord, the second point I respectfully make is that he said that everything is in the law, and those are the steps that the EC is supposed to follow. We know that. We know what is in the law. But the interrogatories are designed to elicit what actually took place in order for your lordships to determine whether they were in accordance with the law or not. So you can't just keep telling us that everything is there in the law, everything is there in the law. We know that. But we have to establish a certain factual basis on which...
We lost with respect, if my learned friend re-arguing.
No, this is not re-arguing a point. He is responding to the issues you raised when you quoted the
Yes, but my lord, it will have to be on points of law, as is the tradition in the courts.
Cousin,
Yes, my lord.
let him proceed.
And my lord, counsel also referred to what Justice Adimira said. And I believe he quoted from page 71. My Lord, I respectfully draw your Lordship's attention to the fact that the decision of Justice Adimira was in respect of an application for further and better particulars. It was not the interrogatories. The interrogatories were dealt with in the decision of Justice Badebe. And in her decision, in respect of the application for further and better particulars, her ladyship actually makes it clear she makes it quite clear that her decision is tied to the fact that there are other applications pending, including the application for the interrogatories. And basically what her ladyship was saying in the passage which I'm about to refer to is that those other applications are sufficient to take care of the matter which is being there. So that decision, which is about further and better particulars, respectfully cannot, it cannot be a basis for the submissions made. And as regards the reference to an obiter dictum of Justice Dateba, the less said about obiter dicta in this particular case, the better. I respectfully submit that far from us coming through any back door, we are actually coming through the front door of the Electoral Commission based on their own answers in order to ascertain the facts on the basis of which this court can reach a just determination.
Yes, for my edification. Question 6. Question 6.
Yes, my lord.
How does it relate to the pleadings so far filed before this court?
My lord, counsel actually claimed that they talked about faxing. Now, all these communication systems, phones, faxes, fall within the authority of the National Communication Authority. And therefore, my lord, therefore, a question as regards whether there was any facilitation by the National Communication, my lord, I need hardly acknowledge that, I mean, the security of, communications in terms of an election process, all those matters are clearly important in the context that your lordships are faced with. So the question whether the National Communication Authority as an institution that is legally mandated to have responsibility for communications facilities in the country by law, whether they facilitated in any way the transmission of results, my lord, is an appropriate question. Respectfully.
Mr. Chikata, this is not one of the grounds which you have stated in your petition for invoking our jurisdiction. Look at your petition. It's not one of the grounds. The mode of transmission of the results is not one of the grounds.
My lords, with the greatest respect, the mode of transmission cannot be a ground for a petition like this. The mode of transmission cannot be a ground. The mode of transmission becomes relevant in an adjudication related to what the first respondent is claiming was done. The first respondent has filed an answer and made certain claims. Now, my lord, those claims don't need to appear in our petition to be relevant. Those claims are the claims that are put in answer, and therefore issue is joined in respect of those claims that have been made in the answer. So the question that we are raising about the mode of transmission is critical, because it is a question that enables this honorable court to determine the authenticity of whatever transmission took place. That question is extremely relevant, and I believe learned counsel for the second respondent claimed that it can be asked in cross-examination and so on and so forth. But we don't need to wait for cross-examination. The purpose of dealing with it at this stage is to avoid having to go through lengthy cross-examination.
Thank you. Thank you.
The court will take a very short adjournment and come back to deliver the ruling.
All rise.